Hello, my name is Ellie Krug. I'm the Executive Director of Call for Justice. Welcome to our training of Greater Twin Cities United Way 211. This is our 25th, very good. This is our 25th training session for 211. Today we'll be dealing with elder law. For those who are subscribers and familiar with the Call for Justice website where the training videos can be found, if you scroll up on the website to training session number 3, Elder Law, you'll see that that is our original elder law training. Today is a supplement, or as we like to say, a revisiting of elder law. And I'm really thrilled to have as our speaker Genevieve Gaboriault, who is a 2005 graduate from William Mitchell College of Law. She's worked for legal aid her entire 10-year career. She started as a tenants' rights attorney and then worked in housing discrimination cases. Since 2012, she has managed the Senior Law Project, which serves seniors 60 and plus in Hennepin and Anoka counties here in Minnesota. She has also been active in the Minnesota State Bar Association and serves on the governing council of the Elder Law section. She has been on the board of directors for Homeline, which, as our folks know, is a very important tenant advice, legal advice line. And she has, this past spring, taught poverty law at the University of St. Thomas School of Law. Please help me welcome Genevieve as our speaker today.
All right, well, thank you. I'm very happy to be here, and I do welcome any questions as we go along. So I'm not going to go over every detail from the original presentation in 2012, but I do want to highlight a few things. And before that, let me just say a few words about my legal aid project so that I don't forget that piece. Mid-Minnesota Legal Aid and the Senior Law Project has been around for about 35 years. We, in 2013, started serving people in Anoka County, as well as we've been in Hennepin County for that whole time. You still can refer low-income clients to Judicare if they're calling you and looking for a referral, but you can also send Anoka County clients to us if they're seniors 60 plus. And the new materials discuss some of the areas that we cover. Of course, like many legal aid offices, our biggest topic area is housing, so tenants who are being evicted, losing subsidies, or need repairs made. We also do a lot with public benefits. Not people who are initially applying for Social Security or Social Security disability, but people who've already applied and are rejected, then we can help at the appeal phase. We do a lot with health care, Medicare issues, medical assistance, which is the state's Medicaid program. People who are receiving home care services and have reductions, we can help them appeal. We do a little bit with grandchild custody. There's not really any group that is covering all of these cases. So what we've decided to limit ourselves to, just as a floodgate issue, is we only assist when the child or grandchild has lived with the grandparents for at least 6 months or a year so that they meet the legal definition of being a de facto custodian. So if grandparents are calling and just want questions about visitation answered or would like the grandchild to live with them, it's most likely not going to be something that one of the legal aid offices can help with. There is a group, kinship caregivers, that may be able to give some advice. They put together a booklet, so that would be a better referral for those situations.
And they're through Lutheran Social Services, yes. Correct?
Lutheran Social Services, yep. And Anoka County does have, at their law library, they have forms and information about grandparent custody cases that you can direct people to. And there are lawyers there one day a week, a few days a week that can help fill in those forms. But there really are no grandparent custody forms available on the state court website, just as a deterrent, I think. We also work on consumer legal issues, and I think you have other trainings about consumer law, but most seniors, by nature of being at retirement or near retirement age. They're receiving Social Security income, which is protected against garnishment. So if you have seniors calling you with consumer law issues, I've got a debt, I've got notice from creditors, I don't know what to do, that's a case that my legal aid office and many legal aid offices can look at and give advice on the debt piece. Yes?
So I've gotten calls from children that are younger than 60 but are dealing with their elder parents in regards to some of these issues. So can they still be referred to you?
The children are under 60?
Yes.
Okay, so the question is what to do when people aren't 60.
Mm-hmm.
So the original paperwork discusses there's a program called the Older Americans Act that funds legal aids all around the country, specifically to help people age 60 plus. And so that's where I come in, and there's someone at all the Minnesota legal aids who does this work. And as the old materials discuss, and I'll highlight now, I mean, we really try to focus on talking directly to the senior. So if people call us and say, I need help from my mom or my dad or my aunt or my sister or whomever, we really are quite insistent that we need to talk directly to that person. So I think it's fine for people to call you and say, I need help, but it's probably not a bad idea to tell them that this is the number to call, but they most likely are going to want to talk directly to that parent. So occasionally, we're not able to represent people if the elder parent really doesn't have capacity or understanding to hire a lawyer or to recognize that there's an issue. So I mean that's very infrequent. Most of the time we can get some kind of consent to work on whatever their issue is, but occasionally that does happen. And then the younger than 60 person's choice, or even if it's an over 60 person who's calling, they really need to find a private attorney or someone else if they need help with an issue.
So just to clarify, can I go ahead?
Well, I was going to say, but if the person calling you on behalf of the adult is a guardian, then you can work with that person.
Yes.
Right? Okay.
And we're going to talk about guardianship later on and distinguish that from power of attorneys, which we will sometimes talk with someone if they're a power of attorney as well, but we still, whenever possible, want to preserve the autonomy of the individual and make sure that we're representing them as our client and want to talk to them.
Okay. And if you get consent from the child or from the over 60 person, that you can go ahead and talk to the child regarding
that happens frequently with all sorts of cases.
And that would be fine then.
Yes.
Got it. Okay, perfect. Thank you.
And this goes back to remember that one of our core training principles, remember the basics, I covered some of this a couple of sessions ago, which is, remember, it's the attorney-client privilege that we're dealing with here. Genevieve's got to be in a position where she has a relationship with the client, not with somebody who is sort of ancillary to the client. And this becomes particularly difficult in elder law because we do get into issues about capacity. Mm-hmm. We get into issues about the elder thinking they don't need help when in fact they really do need a lot of help. Mm-hmm. And this is also the time to talk about, with the caller, the difference between legal problems and legal emergencies. If they're being very astute with you and they're understanding that they're calling about what might be a problem right now, and they can, this is where you remind them, regardless of whether you can work with legal aid or somebody else, now is the time to be looking for the lawyer before this collection letter turns into a collection lawsuit.
Okay. The last thing, just to say on the list that my legal aid program does and that many others do, is we do give advice and referrals on power of attorneys, healthcare directives, and wills. But they are it's a scope problem. They're not our bread and butter of what we do. So we'll give advice on it. We'll encourage you to use it. And if people are calling looking for where can I get these forms, you certainly can send people to Law Help MN. We have not only fact sheets about healthcare directives and power of attorneys, but we also have a form builder so that people can just plug in the information and print out a nice form there. It needs to be notarized, and then it's effective. So I'll just say a few more notes about working with senior clients. You know, people who call 211, just because they're senior, it doesn't necessarily mean that they have an elder law issue. Maybe they just need a referral for divorce or for a tax issue or something else. So make sure you keep that in mind, that not everyone who's a senior has a senior law related issue.
And is that because the Senior Law Project is only dealing with elder related kinds of issues?
Well, many of the topics we do are outside of, well, are not just elder related.
Okay.
But there's not anything particularly special about a divorce for an elderly couple versus a younger couple. I mean, it would still be sent to a divorce help desk or divorce attorneys.
Okay, thank you.
And you do really need to watch out for other people calling on behalf of that senior, because not only is it a attorney-client relationship, but people have different interests. You know, the children are the natural people to inherit whatever property is left behind, and they may have different views about what should happen to it than the parents do, or the grandparents, and those can conflict. So that's why it's so important that we talk to the person who owns the property or who is at the core of the issue. There are kind of, as David Repan did in the first presentation, there are kind of two main pieces of elder law. One of them is probate and trust and estate planning issues, which there are not a lot of free services for that. Most people who are lower income don't actually need to open a probate after they pass away. If your estate is less than $50,000, you don't need to open a probate. You can just work with the banks and.
What's a probate? Is that a will? Or?
Well, a probate is a special kind of court that you go to once you've passed away, and you can have a will or not have a will, but it gets a judge to decide what happens to your property. And so if you have more than $50,000, that's kind of the threshold for when you would have to go to probate. But there are people who spend a lot of time figuring out how to plan for this. If you've got a larger estate, what to do with it, so how can you set up beneficiaries or other tools so that maybe you can avoid going to probate court. So that's one piece, is the estate planning documents. And, oh, yes?
Does that include your residence if you have a TOD?
Yes. The question is about what if you have a TOD. A TOD is a transfer on death deed, which is a tool that became legal in Minnesota in about 2008. And it's a way to convey or to transfer property right upon the time you die. And it's a fairly popular tool if you want to avoid going to probate court. So you can do a transfer on death deed form, record it with the county, and then at the time you die, your house or your cabin or whatever it is transfers to the children or whomever you named on that form. It's generally a good thing, but you still may, if people are calling asking about it, there are forms available on the Minnesota Department of Commerce website for the transfer on death deed. But you may want to caution people that they should consider talking to an attorney. It can be difficult for people who are receiving government benefits, like SSI or Medicaid, to inherit directly. If they are someone with disabilities, it can affect their benefits in a negative way. And it can also be an issue if you want to name several children on the form. Then under Minnesota property law, their spouses all also have to sign off when that house or whatever it is would be sold. So if you have someone who doesn't agree, and you did this to try to avoid probate, you might end up having to go to court anyway to have a judge decide what happens to the house. So,
or if they get divorced.
Well, right, you have to do a new form if there's a divorce. So it can be a really good tool.
Now we're learning why lawyers are valuable.
Right. But I wouldn't want you to watch this video and say everyone should do a transfer on death deed, because it's more nuanced than that. And so are wills, frankly, which is why I don't know of any legal aid offices that do wills for free. because most people, again, that meet our low income standards, you know, we help on critical needs, not on planning needs. The only group that I'm aware of that does them for free for anyone who calls or does them at a reduced rate is the Volunteers of America Estate and Elder Law Services. They're a great group. I think they charge $200 to $300, something in that range for a basic will, more for a trust, which is another document. So they're good to call.
And also, MACV, I think, is doing wills. So the Minnesota Assistance Council for Veterans is assisting with will planning, estate planning for veterans. For
veterans, right. There's some other niche groups. The Alzheimer's Association offers free wills to people when they're first diagnosed. Wills for Heroes does free wills and estate planning documents for people who are like firefighters, first responders. So there are some groups that do that, but by and large it's not necessarily a free service that you can find. So that's kind of one piece of elder law is the planning part. And then the other piece is government benefits. Medical assistance is the state's federal Medicaid program, and it pays for a variety of services, starting with doctors, but then it also pays for home care services, getting nurses or assistants called PCAs, personal care assistants, to come in your home and do everything from helping you get dressed, helping you eat, that kind of thing. They can do some chore services depending on what program you're in. And then medical assistance pays for nursing homes and everything in between. So there's a lot of knowledge about planning to be eligible for medical assistance, spending down so that you can qualify for medical assistance, and then once you receive medical assistance, every year you may have your amount of money that you're allowed to keep adjusted. And so there's a lot of room for people to get notices about changes in services, changes in fees, and have questions. So if people are calling and not sure about what their medical assistance things should be, that's something that legal aids can help with. And medical assistance planning is its own kind of industry. There are private lawyers who work on that, helping people plan how to spend down so that they can qualify for nursing home care and keep as much of their income as possible. So depending on who's calling, what kind of estate, it's not going to be something that legal aid can help with the spending down part, but we can help with the annual kind of assessments. Are you getting the right service level, and are you being charged the right amount for your portion? Estate and elder law services from the VOA, they will do some medical assistance planning, particularly at the eligibility when you're first trying to get on the program. So you can talk to them or refer people to them as well.
I actually have a question.
Sure.
Would this be, so would I send this, so like I've gotten callers before who are, you know, maybe they're just like right above the you know, FPG for them to get on medical assistance, but then the Medicare that they have, right, like it's just, they're spending in too much, so at the end of it, they're just not able to meet their basic needs. Is that a referral that I would refer to you guys, or would volunteers of America? Because I've gotten a couple of those calls where it's just kind of like,
Do you want to repeat the question?
Sure. So the question is it better to send people who are close to being able to spend down and receive services, but not quite? Is it better to send them to legal aids or better to send them to estate and elder law? It kind of depends. I mean, there is, if you can get below the $3,000 asset limit to get home services or services under a waiver, like an elderly waiver or a caddy waiver, those are services that'll pay for things in your home or in your apartment, or they may pay for assisted living as well. But you say you get $1,200 a month as your monthly Social Security check. I mean, there is just no way to get around that you have to spend down towards your benefits. So the spend down amount varies, but for a single person, you only get to keep about $700 some. And for some people, that does mean that they have to try to apply for subsidized housing, or they can't stay in their current home. There is a program called the Group Residential Housing, GRH, that's run through the state. You would refer people to their county workers to see if they can qualify. And that kicks in $877 towards housing, towards rent. But they still, depending on how much their medical needs every month are, would have a spend down and may have to spend down the rest for their medical needs.
Is GRH for seniors too? Because if I remember, I know we had a training on it about that, but I don't remember. Was it for like if you're chronically homeless and disabled maybe, or no?
And let's explain to the viewers what GRH is.
GRH is Group Residential Housing. It's state money for rent assistance. And I don't know all the categories, but I'm not aware that there's a cutoff that you're too old to get GRH. I've had seniors that received GRH. And it pairs really well. Why don't we start talking about assisted living, which is in the new materials. It pairs really well with assisted living and housing with services because essentially you spend down your assets or you didn't have assets to begin with. And then you can get on medical assistance and have an elderly waiver or a caddy waiver to pay for your services.
Could you just explain in more detail, I guess, the spend down? Because the way that I'm understanding it is that you have to spend it on medical expenses, or is that not correct?
So the theory of the spend down is that it costs you a lot of money every month for medical bills. And so the state just has a formula for how much money you get to keep. And if you're a single person who's disabled or elderly, you only get to keep about $750 a month of your own income. And all of the rest, even if you make $1,500 a month from Social Security and pension or whatever it is, all of the rest has to go pay your medical expenses. So if you have fewer medical expenses than what that $1,500 is in income, let's say your imaginary income, and the $750 or so that you're allowed to keep, you may be able to keep that difference because what happens is you're actually billed by your doctor or by whomever, and you have to pay the first part of that bill, and then the state picks up the rest of the tab.
So if you have more, like if you have less medical expenses, then it doesn't really make sense to become involved with the state, right? Because it would be cheaper to do it on your own because they wouldn't mandate that you only keep $700. Am I?
Well, right. If your medical expenses are light, you may want to talk to a county case manager about if you should be on medical assistance with an elderly waiver or if there's another program that would be better for you.
So this is only for people that are on, that most likely have a lot of medical expenses and qualify as low income, right?
Yes.
It's not for people that, for whatever reason, get $5,000 a month. And I mean, it's only for low income.
Right. I mean, if you have a high income and can pay for your own private nurses and can sustain yourself that way, that's fine. You don't have to worry about it.
Okay, but most people, even if at some point weren't low income, when they hit age 65, will fit this category because of their medical expenses?
Many people require medical assistance. Many people, because they maintain supplemental insurance, regular insurance, and they have a significant enough pension and Social Security or 401ks, they don't require medical assistance waivers. The waivers, what they really add that you can't get from your regular insurance for the most part is home care services. They will provide like an independent living skills worker who comes in and helps do bills, helps find you a new apartment, helps manage daily tasks. It provides for a nurse to come in and do medication checks and medication setups, provides for a lifeline necklace perhaps, and it's very individualized to your needs. But the theory is that it's cheaper to keep people in their own homes than to pay for them to be in a nursing home, because a nursing home is $6,000 to $7,000 a month in the metro, depending on your care needs. And so it's cheaper to have formulas and have some cost sharing for people to receive Medicaid and have to spend down and put some of their income towards the bills than it is to have them all just be in a nursing home. And it aligns much better with our state's goals under the Olmstead Act, or Olmstead Plan, which was a U.S. Supreme Court case that now Minnesota is going through a lot of steps to kind of enact as part of another case settlement to encourage people to have as much choice of where they live and live in the least restrictive setting. So instead of having everyone just be in a nursing home, if you can be at home and have a nurse checking in and helping you get dressed, and that's where you want to be, it's about choice too, that's a better place. So there is an Olmsted implementation office that's part of the state. It's just a 2-person office. But that may be a good referral too if you've got people saying, I want to be at home, but my nurse or someone else is saying I have to be in a nursing home. You could certainly contact the Olmsted implementation office through the state, and they could look to see if it's a state or a state paid health plan telling you that you can't be somewhere, then that would be potentially cause for concern.
Don't knock 2-person offices.
True. They can be very powerful.
One thing I do want to add is, there is a percentage, I don't know what the number is, of people who, as they're getting older, don't want to utilize their assets for nursing homes. And they want to give their assets away to children or loved ones and then spend down and qualify for medical assistance. And you may get some callers along those lines. That is an automatic referral to a private, tell them they need to find private attorneys to deal with that. In part because in some ways that I think is disturbing generally to the nonprofit legal community about helping somebody with assets, distribute those, because that ends up taking the place of somebody who doesn't have assets. It's all one big pot. So just be aware of that. Here we go. And so those calls go to, private, send them to the Bar Association. So remember the Ramsey and Hennepin County Bar Associations, they have probate lawyers, and they'll be able to make a good referral. So they'll need to use some of those assets for lawyers to help them do what they want to do.
Mm-hmm. Yes, agreed.
Okay.
So let's talk a little bit about assisted living and nursing homes. That's in the new materials. So many people receive medical assistance services in their own apartment, and that's fine. It's a private apartment or a subsidized apartment. But many need a higher level of care, or they want more services, and so they move into a seniors building or a seniors and disabilities building that includes services. So if people are calling in not a nursing home, but some sort of an apartment that's got a lease, and these all should have leases, and have services as well, and they're having a problem, then those would still get all of the same housing referrals that you would normally do for tenants. You could still send them to housing court, you could still send them to all the legal aids, to Homeline, to whomever else you would send someone who's having a problem with the landlord, because the assisted living and housing with services buildings are governed under the same laws, 504B and Minnesota statutes. So people who live in those assisted living or housing with services buildings and are threatened with eviction or given notices to move out, the landlord still would have to file a case in housing court or in whatever county court to evict them if they want them to leave. Under the lease, that's about who gets to live there, who has possession of the unit. And then there should also be a separate contract, which is the services contract. And housing with services, assisted living, and they're just different designations that the state gives them depending on how much services they get. It doesn't really matter if a caller tells you one or the other. You can treat them the same. But they have the right, if they want to, the landlord can cancel the services contract. So you may get callers saying, my services contract was canceled. Usually it's because of behavior issues. The resident is not doing enough housekeeping or is belligerent in some way, usually related to a disability. So one really good referral for that kind of situation when the services piece is not working well is to the ombudsman. The Minnesota Ombudsman for Long-Term Care are excellent at handling referrals related to service issues, housing issues. They serve the whole state. There's a main phone number that you call or that the client would call, and then there's assigned the ombudsman for their region. And the ombudsman they're free advocates for the clients that the state provides, but they have such regular contact with the nursing homes or the buildings that they're going to that they really can solve things quickly. So if there's some sort of crisis, oh no, I got this notice that they're terminating my lease because of my behavior issues, the ombudsman can often solve it. You know, talk to the client, talk to the manager, look at what notes were in the file about what's been going wrong, and solve it. And the person can stay, or they're also good at figuring out that, well, maybe this isn't a good setting for the person anymore, and the client agrees, fine, I'll move. The legal aids in the state work really closely with the ombudsman, kind of like the backup that they call if they're not able to solve it on their own. So I think it is reasonable if people are calling to say, try the ombudsman first, and then you can also call legal aid, or that the ombudsman know to refer to legal aid as well. And the ombudsman for long-term care, they help people in the whole range of housing settings. So from nursing homes to assisted living, housing with services, and to people in their own private homes but that are having problems with the services they're getting. The number of personal care assistant PCA hours or whatever else in your own home they can help with as well. And then the state has another group of ombudsmen, the ombudsman for mental health and developmental disabilities. I don't work with them as much because all of my clients qualify under the long-term care. But if people are having issues with a mental health provider or some other service related to their mental health, that's another good referral that you can make. The other kind of government agency that, go ahead.
I'm sorry, Genevieve, I have to supplement the training material to have something more about the ombudsman, but is it one number for the ombudsman, or, because you've been talking about them doing different functions, and that number shows up in our original training, but is it just one number for them to call, or are there different offices, different ombudsman offices that we need to be concerned about?
I would have everyone call the main phone number. There's a 651 number, which I don't see in the original materials for people who live in St. Paul, or it's cheap, free to call 651, but there's an 800 number. And if you send someone to the ombudsman for long-term care and it's really an ombudsman for mental health issue, that's fine. The offices work together. They're both mostly housed at the DHS main building in downtown St. Paul, but people who work in the other counties have satellite offices as well, and they work very collaboratively.
And I'm seeing on our original training material, which would have been really good for me to look at before I ask the question, which is that we do have listed here offices of the Ombudsman for long-term care, and then an office for mental health, each with a different 800 number.
They're in our database.
Good, great. So, thank you. I was thinking of our viewers back home.
Oh, great. I'll try to keep a mind towards that. Okay. Any other questions about the Ombudsman? All right.
No, and I guess one question I have is mechanically, could you just explain, will the Ombudsman actually come to the home of the person at need? And mechanically in terms of timing, how quickly will, generally will it work?
Okay.
Somebody drops a dime, makes a call.
Right. The Ombudsman try to work very quickly and efficiently. They do, from what I understand, they do a triage just like legal aid does, so the most urgent cases they would get to first. Many of them have rounds, they have people that they see every week essentially at different facilities, and so they'll get the person in on that weekly visit. But if it's more urgent, they certainly go out faster than that. And they do try to meet generally in person. It's just a better way to talk to people, get information, and then they can go right from talking to that person to the office at the building and talk to management as well and find out what's their side of the story, how can it be resolved. So once a call is made, again, it depends on the situation, but it can be very, even that day that they go out and start working with the person. And then ombudsmen, generally, if they want help from legal aid, tend to work on the case for a while, decide that it's going to have to go to a hearing, or that there's not, the building doesn't want to change its mind just based on the ombudsman's involvement. And then we'll call and say, can you open an intake and start working on this case? Here's the issue. I think we're going to need support. And then we generally work in concert, continuing on the case. Sometimes we'll just take it over. It just depends on the situation. But there is generally a very close relationship between our office at Legal Aid and the Ombudsman's office.
How long does the ombudsman usually work with a client? Like, is it just like a one-time thing and it's resolved within that? Because, I mean, let's say it's not resolved, is it how long?
I think the question is, how long does the ombudsman work with the person? I think they open a file and work on it until it's done. Either the person has moved, gotten a different service, or the original issue is stopped. So they work until it's resolved in one way or another. Or, just like the residents and clients can say they don't want help from me anymore, they can also say, I don't want help from you. And they could hire a private attorney or do something else. So the other office that's good to keep in mind when people are calling with complaints about facilities, if it's a nursing home or any place where long-term care is received, is a state office that's housed as part of the Minnesota Department of Health, and they're the Office of Health Facility Complaints. They've got, I think, a 651 number. But they're where you call for anything from problems with, I don't like the food, I don't have privacy in the bathroom like I'm supposed to have, to I'm getting abused in some way. And they are overrun with calls of complaints, as you can imagine. Some very serious, some not as serious, and they do they have requirements for how quickly they respond, but if it's serious abuse, physical or sexual abuse, they'll be out there that day to start investigating. They also kind of triage what happens. And they take complaints from the public and from individuals, and they certainly want things to be resolved, but they're not an advocate for the person the way an ombudsman is. They want to check to make sure that everything is done right and that licensing is right, and they can issue fines and deal with things from that perspective. It's more of a regulatory office, but it's a good resource if you have complaints about services or facilities. That's where you can send people as well. Yes?
Where does the Office for Adult Protection fit in to any of this?
Sure. So adult protection is a different animal altogether. Every county has its own adult protection agency, and as part of trying to make it simpler for the public and for everyone else to find out who to call if you suspect vulnerable adult treatment, and that can include neglect, abuse, sexual or physical abuse, maltreatment. It also includes financial exploitation, and it can include self-neglect. So what the state has done, effective July 1st of this year, they have a new common entry point or a new phone line that you can call. It's called MARC, Minnesota Adult Abuse Reporting Center. I see some heads nodding, so the word has gotten out, so that's great. If you still send people to the individual counties, I believe it will get filtered to the right place. But this is where you would send people who are calling saying, I think something's not right with a neighbor or with my aunt or whatever your issue is. And this is where to send people to make that report. People are encouraged to make reports of suspected maltreatment, or abuse or neglect, and that triggers an adult protection investigator from whatever appropriate county where that person lives to open up a file. And then they go from there and see if the call is founded or not founded or whatever.
So this would be for persons that are living in their homes alone. If somebody is complaining about the way that they're being treated in a nursing home, it would not go through adult protection?
So the question is if this is for people just living at home alone, or if this would apply to people living in nursing homes as well, or anything else. And you can use this for anything.
Okay.
People who are nurses or licensed providers who work in nursing homes and other facilities, they're mandatory reporters, so they have to report, and they can call the MARC system, the new phone line, but they also have a computer portal that they can just enter data into when they think that there's abuse, maltreatment. A lot of times people enter, if there's suspicious looking bruises from nursing homes, they need to be investigated to determine if it's related to just falling or if it's something else. So, and I think they don't know how many reports are going to come from what source, but they all get investigated. And there's no wrong. If you think that somebody that you see at the nursing home when you're visiting your grandmother and you see somebody else who looks like they're having severe problems, you certainly could call this hotline as well.
So in terms of referrals, this would be just as good a referral as the ombudsman, or it would?
Well, so the Minnesota Adult Abuse Reporting Center is where you would refer if you think that people are being self-neglect or abused or financially exploited.
Okay,
those three things. For you to report about someone else that you're observing. If you're calling or you're calling on behalf of someone who is having problems with services or with something in their facility related to their care, and it's probably not abuse, but it's, threatening to terminate services or something like that, then an ombudsman would be, or the Office for Health Facility Complaints would be who to call. Good questions. Let's see.
Do you want to talk about the nursing home report card,
Sure.
since you're sort of on that topic?
Yeah, let's talk about nursing homes next.
Everybody has a copy of that.
Oh, wonderful. MinnesotaHelp.info is a great resource that the Senior Linkage Line maintains to talk about all sorts of different services that you can get based on your county, from home care to legal to a lot of different services. And an offshoot of that is this new product. It's the Minnesota Nursing Home Report Card that's only been up for, I think, since March. Don't quote me on that, but it's new.
Hold that up.
Sure.
Very good. Thank you.
And this allows you, right now it's just nursing homes. I believe the intention is to expand it to other services, but this allows you, if you're shopping for a nursing home, if you need to go to one, either permanent or on a short-term rehab basis after a surgery or a fall, something like that, this allows people to compare and contrast, look at the number of beds overall, what kind of services they have, that sort of thing. So this is a nice new feature for people who are trying to comparison shop for nursing homes. Nursing homes, unlike assisted living and any other kind of service that's paid for with Medicaid, they're also paid with Medicaid, but it's completely different calculations. There's different spend down issues, and there's a whole industry around of private attorneys who work on spending down and how you can protect assets and keep as much of your estate as possible and live in a nursing home. Some people call, if you live in a nursing home and you have a spouse who still lives in your community-owned house or your apartment, they're allowed to stay there, and some of your money can go towards supporting them staying in that home. But in general, if you live in a nursing home, all of your money goes to the nursing home except for $98 of personal needs allowance. Because the nursing home pays for your housing and your food and your care, so that $98 is what you have left over to pay for haircuts or candy bars, entertainment, clothing. So it can be really hard if you don't have a family to help purchase some of those things for you. But the alternative is, not many of my clients can afford the $7,000 a month out of pocket. So it's a trade-off for how to pay for it. And because of that, and I should mention this, because so many people, their resources do go towards medical bills, towards Medicaid spend downs, towards nursing home, legal aids under the Older Americans Act, so all across the state. We can help people that on paper are above 200% of, or 125% of the poverty lines, because really they don't have access to any of those resources. They only have $98 a month, and you can't hire any lawyer for $98 a month. So just because someone has a higher income, that doesn't mean they're screened out from legal aid. And they're also not screened out from the Minnesota Disability Law Center. That's another statewide legal service. We're part of the same corporate entity, but they focus more on disability-related accessibility issues. And they're a good referral. So nursing homes, I've just put a little bit about how nursing homes are regulated. There is a tiny tidbit in Minnesota housing law that says that residents in nursing homes still are protected by Minnesota landlord-tenant law. The only time that really comes into play is if someone from a nursing home goes to a hospital because they fall or have some other acute need, an infection or something that needs to be treated at the hospital, and then occasionally the hospital tries to send the person back to the nursing home, and the nursing home says, no, I don't want them back. And so we have had clients, and the ombudsman have had clients that are successful in filing cases in court saying that they actually were effectively locked out when the nursing home is refusing to readmit them. So landlord-tenant referrals could be used for nursing home cases, but in general, nursing home law is governed very heavily by federal laws. And so I included the 6 reasons why residents can be discharged in the new materials. And Ellie, do you have the copy of the discharge notice?
I do, absolutely.
Handy?
Which everybody would have gotten with their packet. There you go.
Thank you. So you may get calls, it looks like this. You may get calls from some residents in nursing homes who are threatened with a discharge. And generally what happens is the nursing home administrator or the social worker walks over to the resident and hands them a piece of paper that says you have 30 days to leave. It says this is to notify you that X facility will discharge you on whatever date. And then it has to give you the reason for that discharge or transfer. And there are 6 reasons. So the first is that the nursing home closes. That one I have never seen, but that one's hard to argue against. The second one is that your health improves, which many people, again, just are going for a short stint kind of as a rehab, and then it does make sense for them to go home, and maybe they get home services at home, but they don't need to stay in the nursing home permanently. The next is that the person owes rent. That's generally because they're not paying their portion correctly. Frankly, often it's because they have a spouse in the community who isn't writing the check that he or she is supposed to write. So that happens occasionally. And then the ones that come up more often are that either the resident is engaging in unsafe behavior, or they're putting other residents at risk. And then the last one is that the facility can't meet the residents' needs. So the last few about behaviors and not meeting their needs, I think those are kind of pretext for the person's difficult. They've got, a lot of people with dementia or Alzheimer's, or not necessarily Alzheimer's, but just heavy health needs, can have behavioral outbursts, be belligerent, be uncooperative, and if there's no one there to advocate for the person, they can just be shoved to a different nursing home or moved out of the facility if they don't put up a fight. So if people call when they get one of these notices, you certainly can encourage them to read the notice. There is 2 places where they can write letters saying that I don't want to leave. If the issue is that they think the state is calculating their part of the spend down wrong, which I've never had any of those appeals, they would write to the Minnesota Department of Human Services and say that it's being calculated wrong. But if you're being discharged for any other reason, that you owe money that you think was calculated right but you just didn't pay, or any of the other reasons about your behaviors or anything else, then you refer that person to the Department of Health, to the appeals coordinator. And then the notice tells them exactly what has to go in the letter when they request an appeal: their name, the name and address of their nursing home, why you think the discharge is improper. You know, I haven't broken any rules, or what, you know, I've got schizophrenia and I have the right to be cared for, whatever the issue is. You ask for a hearing, and then you send this off. So we always tell people, and I know that you can't tell people deadlines, but we always tell people to wait till the end of their 30 days to appeal, because that buys you extra time. If you can calculate your 30 days and put it in at the end, then you'll have a hearing scheduled within about 2 weeks of that time. So it can stretch out the process, and maybe during that time you're working with family or with a social worker and can work it out to stay there, or perhaps you find a different facility that you like better and agree to leave, so you don't need to have the hearing. But once you submit in writing your request, you'll get a call from somebody at the Department of Health asking when to have a hearing. And they do try to make these as client-friendly as possible. So the judge comes to the nursing home, the hearing is held in a conference room there, it's voice recorded on a tape. The resident who's threatened with discharge has the right to have a lawyer, but they don't get one for free, but they have the right to have one. They can have their own witnesses. They can review their file ahead of time. So it's all the kind of regular due process rights are part of this hearing. But it is not nearly as formal as being in court. So people do these on their own all the time and explain whatever they think happened and say that the facility has to keep working with me and keep treating me, or whatever, or yes, I'll pay, or whatever the issue is. And then another nice thing about the discharge notice is that it gives the phone numbers for the Ombudsman for long-term care as well. They're a very good resource to help when there's a nursing home discharge proposed. Yes?
So would legal aid, or would your service or the Ombudsman come to that hearing?
Yes. So the question is, will legal aid or the Ombudsman represent the client at that hearing? Yes. If we're asked to be there, we review the case. If there's any kind of merits, then we'll represent whenever possible.
And Genevieve did mention, and I'll just reinforce, you know, if you get somebody calling saying, I'm looking at this notice, it says 30 days, how do I do that? You know, your answer is you look from the date of the notice and you can count out from there, but we do not do the counting for them, okay? That is absolutely just something we don't want to get involved in. They can count, and that's really the case with anyone calling you on the phone saying, I'm looking at a deadline for X or Y here, you know, what is the deadline? Your answer has to be, you have to figure that out. Okay, or send them somewhere, obviously that's what we want to do, is send them somewhere where somebody can help them figure it out on a quick basis. But you don't want to be in the position where you tell them, because, for example, with a notice of appeal like this, you're 1 day off, it's not, you know, it may not be forgiving. You know, and the last thing anyone wants to hear is that 211 told me this was the day. So, okay.
Correct. Anything else about nursing homes or other facilities before we move on to guardianship and conservatorship? Okay, great. I just wanted to say a word about guardianship and conservatorship. This was not covered in the original materials. And if people are calling with questions about guardianship or conservatorship, you should know a little bit about it. So guardianship is control over the person. The person's called a ward. And a conservatorship is about money and the person's financial estate. And in order for either one of these to be put in place, somebody has to petition court asking for a guardianship or a conservatorship to be appointed. There can be emergency quick processes if there's extreme harm to the person, but generally it takes a little while. The person who is at debate for whether they should have a guardian or not is guaranteed to get a free attorney appointed for them by the court. If they have money, then it can be paid for out of their own estate. But if they don't have resources, then they get someone for free, and the different counties have panels of attorneys ready to take these cases. Because Minnesota, like many other places, we really don't want to take away people's rights without a thorough investigation about whether they truly are at risk to themselves or wasting the estate of its finances. So it's a pretty high bar. It's not just making bad choices, but making really bad, unsafe choices that you're hurting yourself with to have a guardian appointed for you. So many legal aid offices, actually I don't know of any free law offices like VLN or anyone else who get involved in guardianship or conservatorship because you already are appointed a free attorney through the county where the petition is filed. We get people who call saying that they have a guardian and they want to have that guardian switched. They don't like the guardian, and that's frustrating. You know, guardians are supposed to give the protected person, the ward, as much choice as possible. You know, they're allowed to date, even if they don't like the people. They're allowed to vote unless it specifically says they can't vote in the guardianship paperwork. They're allowed to marry unless it specifically says they can't. So there are a lot of protections built in for that person. And if you are restored to capacity, if doctors or other people say that yes, you know, they had a mental health issue or whatever it was, but now they can make their own choices, you have the right to petition the court to have that guardianship lifted, and you'll get appointed a free lawyer again for that petition if you can't afford one on your own. Conservators have a lot of safeguards built in as well. If you have an estate, they have to be bonded. So if they steal from you, there's a way to recover that. They have to make a report every year to the court about what they're spending money on, and they can't sell a house or other big assets without court approval. So they really are quite protected, regulated things. They're considered substitute decision making because you're not allowed to make your own choices anymore. Somebody else gets to make them. Stepping down from that is something that we talked about briefly, which is power of attorneys and healthcare directives. And power of attorneys, you still have your right to make your decision, but you're also giving someone else the right to help with money things. And as I said, power of attorney forms are available at lawhelpmn.org. Because of some law changes in 2014 that made it really clear that power of attorneys are serious things. You don't want to just give your kids the right to spend money willy-nilly because there is so much financial exploitation that happens, people stealing mostly from family members. There are a lot of warnings now saying this is serious, make sure that you can trust who you choose, and there are oversights built in about having other people get copies of what's spent, that sort of thing. They've really improved, I think, the power of attorney form. But you still have the right to make your own choices. So I get calls from people saying my power of attorney says I have to stay in this nursing home or that I can't do this. And I know you can't give legal advice, but you could maybe point them to the fact sheet that Law Help MN has about power of attorneys, that it's not taking away your rights. You still maintain your own right to spend money and decide things. And you can also revoke someone's power of attorney if you wish, and that's listed as part of our form as well. If someone's getting too pushy about things or you don't trust them anymore, you can revoke. Yeah.
Go ahead, Alyssa.
Okay, I was just, the guardianship and the conservatorships, with that, so say I was concerned about my grandparents, I could say I believe that they need one of these two things. So is that how that process would get started, or would it be like my grandparents saying, you know, I think I need this? Because it sounds more like, I mean, by having one of those, you're kind of not at the capacity to be able to handle certain things. So is it somebody else making that decision saying, you know, they really need this? Or is it more of a decision that, like, if it were me, I could make the decision saying, I really need this?
Well, so the question is who petitions for guardianship or who makes that decision. And if you still have mental capacity to realize that you're going to need assistance with things, there's really no reason to have a guardian or a conservator appointed for you. You can do it through these other things. You can give someone power of attorney so they can help you with finances, and you can pick someone to be your healthcare directive so they can help make healthcare choices and look at your medical records. And then you can set those up so that they continue after you lose capacity to make your own decisions, and they just kind of continue until you pass away.
So in that case, it would be essentially the power of attorney or that would take over those things.
Mm-hmm.
So if I were making that decision myself, but if it were somebody else that were making the decision for me, is it something that they can say, well, I should take over guardianship, or is it somebody else that would be appointed to the person needing the service?
Well, so the question is who takes over guardianship and how does it work? I mean, most people, you have to have a guardian or a conservator appointed because the person isn't agreeing, isn't going along with it, and is making bad choices. So if the grandparent or whoever the person is who's not able to make their own good choices anymore, if they're agreeing with the family and the family is taking care of them in an appropriate way, there's no need to ever get the court involved. So a lot of times guardians are involved or the court's involved when there's not family agreement about what should happen, when the person doesn't agree and the person continues to make dangerous choices.
Right, but at that point, is it somebody from the family that becomes the guardian, or is it somebody that's court appointed? Well,
the court appoints someone to be the guardian, and they look at interested people. If there's a family member who could do a good job, it could be a family member. There's professional guardians as well, professional conservators as well, and family conservators. So it just depends on that individual's situation. Most of the time, a guardian or a conservator is appointed because there's all sorts of trouble. Maybe there isn't a family that's helpful or capable, and then the court will appoint a professional person.
Genevieve, isn't there such a thing as a standby guardianship that you can get set up in advance? If some conditions are triggered, then the guardianship would arise?
Minnesota does have a standby guardian statute. It only lasts for 60 days, and then you do need to go to court to have something more formalized and longer lasting put in place. I haven't seen the standby guardian statute used for lack of mental capacity. I've seen it more often used for like parents who die and want something to happen to their kids. Until something more formal can be put in place. It's not generally used in this way.
Not in a long term.
Right.
And then the other question I had is, while you're describing the power of attorney and the healthcare directive as good tools for folks who still have capacity and you know, where the person at issue is still able to make some decisions, how about when you get into situations where you're dealing with third parties, like nursing homes and other institutions where they actually they're concerned about legality of things and they want to be dealing with somebody where there's no question about capacity and they want to deal with guardians versus dealing with the person who might be at questionable capacity?
I think that nursing homes all handle this differently.
Ah, okay.
There doesn't seem to be one way to do it. You know, I think that nursing homes could be helping petition for guardianships more often than they do.
Okay.
When it's unclear who should be in control, you know, because a lot of times if the resident doesn't have capacity anymore, they'll turn to the children, whether it's formally written in a healthcare directive or not.
Okay.
And then if the children don't all agree, I mean, it gets to be smushy.
Okay.
So, you know,
right.
Nursing homes, it's not their business model to apply for guardianships. It takes time and legal, you know. So I think some people, it's messy.
Okay. All right, which raises, I think, the more important thing is that when you're dealing with your callers who are like entering this world, okay? And everyone in this room, if we have elderly parents or parents who are going to be elderly, will be entering this world maybe in one way or another. And I think that that answer is, is give them the resource, generally like linkage line or someplace where they've got to go to, and let them, learn the ropes, and of course you can, on legal things, refer them to law help. There are many papers on law help that they can get some assistance on elder law. But unfortunately, in many respects, people have to learn these things, right? So, okay, go ahead. And what was your question, Melissa?
So who usually does file these petitions? Like, I mean, when you're saying it, I'm thinking of like children, but like who else can do it like outside, like in a social service aspect? Like, can a social worker, can a doctor, can, what other parties are able to file these petitions?
Sure.
On behalf of these?
The question is who files the guardianship and conservatorship petitions. Often it's a family member, but it can also be an adult protection worker, someone from VOA, social services. They file many. I mean, they try to find a family member to do it, but they do have to file some occasionally as well. I mean, again, the thrust of where Minnesota is moving is to try to have fewer guardianships and conservatorships and try to just have other models to support good decision making, to have alternatives so that we don't have to have courts telling people what to do. But these are still necessary for some of our most vulnerable folks and are going to stay around. So, and there's no rule about only certain people can petition, but there is doctor evidence that's part of it. It's a lengthy process. It's not just a judge signing off on an order that one person petitions.
So like, could a neighbor do it? Let's say like a neighbor's like, oh, I've been helping this person. I don't trust the kids. I think I'd be a good fit. A neighbor
Right.
could go do it?
Yeah, there's no reason why a neighbor or anybody else couldn't do the petition. It's someone involved though, so I think you'd be pretty serious to be part of it. More likely, I think a neighbor who's concerned should make a call to Adult Protective Services and have an investigation opened. And then the adult protection worker can loop back with that person and can decide if guardianship or conservatorship is appropriate.
Remember, we encountered this issue with civil commitments. You may recall that one of the things our speaker talked about is that for civil commitment, that somebody bringing the civil commitment can be a doctor, could be a social worker, or it could be a neighbor who is concerned about their neighbor. I think the key takeaway for you and the key takeaway to relay to your callers is that this is a process that has checks and balances. That ultimately there is a judge who makes a decision to protect the rights of the person at issue. That ultimately there is a lawyer who's involved to represent that person. Either the person at issue can pay for it, or one is appointed. So people don't, either in the commitment sense or the conservator or the guardianship, no one ultimately is just simply at the mercy of a system that doesn't work to protect them.
Correct. And Ellie,
Sorry. I got one more, and then I'll stop. And I may be jumping the gun here. So I've gotten many calls before where the caller's like, I have conservatorship or guardianship and I want them gone. I'm done. Like, how do I get away from them? So what options do they have?
Yeah, and what option should be the referral for that call?
Yeah.
right. So what to do when someone calls and says, I want to get rid of my guardian or my conservator? Again, there's not a lot of referrals besides just asking them to go back to their court-appointed attorney that they had last time to ask for a new petition, to ask to have it lifted. That person that held them before, or the court, whatever county they're in, can appoint a new person if that attorney is not on the roster anymore. It's supposed to help them ask the court to have it lifted. Unless they've got new evidence from a doctor or something else, it's unlikely that it's going to be lifted. But they do have the right to have an attorney help them try to change it.
So go back to their old attorney.
Right. Because
how about a power of attorney then?
a power of attorney, all you have to do if you want to revoke that is, it's just a paragraph form saying, I revoke the power of attorney granted to so-and-so, and sign it and date it and notarize it. And we provide a copy of the revocation form. It's the last page of our power of attorney fact sheet on Law Help MN. It may be other places as well, but that's all you have to do to lift the power of attorney, because you still have, you're the one who gave it, you have the right to take it back. And all you have to do if you revoke it is make sure you give a copy to the person who was your attorney, in fact, and make sure you give it to your bank and other places to stop that person from spending money anymore. There's a, oh, go ahead.
But to get a power of attorney, do you still have to file that petition?
No, 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 a power of attorney is not through the court at all.
Okay.
It's just paperwork that you do and then you get notarized.
Okay, thank you.
Yep, the court doesn't have oversight of that, and there's no registry of power of attorneys or healthcare directives. You can't look to see if they're recorded anywhere. They're just papers that you have that you give to other people to use, and then you have the right to withdraw them and revoke them if you change your mind.
But they have to be notarized.
You were going to ask me something?
Well, I was going to ask if you could mention the emergency guardianship panel, since we're talking about
Sure.
guardianship.
So this is not on your training paper, so please add this, that the Lawyer Referral and Information Service in Hennepin County, so this is really only Hennepin County residents, has a, well, might not only be Hennepin County residents, but they have to call the Hennepin County Lawyer Referral Information Service. They have a panel of 9 lawyers who will deal with guardianship and conservatorship emergencies. So these are lawyers who have been vetted, who have experienced in probate law, who will, on either the day they're called or the next day, meet with the person to speak about the guardianship or the conservatorship, and then be prepared to file something in court. This will be added to a supplement that we will do. I found out this information after we went to print. So, okay, great.
The last resource that I'll mention then is the Elder Justice Center. They are out of William Mitchell. They have been around for less than a year, but they grew out of a wide stakeholder group that's worked on vulnerable adult issues. Financial exploitation in particular has been their focus in the past few years. And they, I don't think they're in their materials either. They're looking at setting up a panel of free attorneys to work on cases. They also just have a lot of good research and resources. So if people call, particularly with financial exploitation questions, you could send them to the legal aids or to VLN, but you could also consider sending them to the Elder Justice Center for materials.
And we will be getting you that contact information too. So,
that's all that I had. Thank you for listening. I think you have some announcements.
do you guys have any other questions for Genevieve before we end? Okay, well thanks. Let's thank Genevieve very much. Thank you, Genevieve. What a great presentation, very helpful. Okay, we have our training next month is in September. I'm not certain about what our training topic will be, so please, if there's something in particular you want us to cover, either that or we'll go back. We are slowly working over the training topics that we did not videotape. For those of you who are our long-termers, and it's getting to be fewer of you, you may recall that we did not begin videotaping our training sessions until we were at, I think, training session 4 or 5. So slowly we're going back and videotaping those. So we have a complete library of all of that. Apart from that, the Call for Justice annual report will come out, our very first annual report will come out in September. Look for it. It will tout many of the successes with our collaboration with 211. We in particular have had a wonderful success with Minnesota Legal Advice Online, where we will describe that in the report. Please remember to be referring folks to Minnesota Legal Advice Online. Elder law here is a wonderful example of an area where people generally may have general questions, particularly like grandparent rights, or about conservatorships or powers of attorney that maybe they're not going to be able to pick up from law help, but it's not an emergency. Send them to Minnesota Legal Advice Online. They can post the question, and hopefully they'll get a response back within 14 days. It's just a perfect vehicle for that. Anyone else have anything else that you'd like to raise? Okay, well this concludes our 25th training session with United Way 211. For those of you viewing at home, we hope that you're enjoying our training sessions. We hear from you with some frequency from folks across the country who are finding these sessions to be of value. Please, we are a nonprofit that operates by way of donors. We would love to be supported by you. So our contact information is on the website. If you make a donation to Call for Justice, you will get your very own certificate entitled Friend of Justice, and it will even have your own number. So we are up to a number about 100 for certificates on Friends of Justice. So be 101, please. Thank you very much, and until next time, have a good time. Have a good life.